Shocking footage, real cases, real justice. Justice now.
Okay, this is a termination case, and as I'm recalling, mother-daughter. Is that right? Okay. Is it your house, ma'am?
Yeah, I'm on the lease too. So we're both on it.
Okay, are you renting this place from somewhere else?
Yes. It's an apartment.
Okay, so, ma'am, let me ask you this. I don't have a copy of the lease. Are you disputing that she's also on the lease to the apartment?
No, I just wanted her out for my well-being.
No, I hear you, but I've got to have a legal basis in which to do that. So, you're both on the lease to the premises. Is that correct? So you would agree that Larissa,
Her
right?
name is on the lease, yes.
That both of
She's
you are
over
the,
18.
pardon?
Because she's over 18, yes, she had to be put on the lease. The Section 8 housing voucher is in my name. And they told me since she won't move out that I have to evict her.
Oh, boy.
Yeah.
All right. So you've got a leasing agreement. There's a Section 8 voucher. What is the portion of, so how much do you pay?
I pay $374 a month.
And the voucher takes care of the rest of the rent.
Correct.
How much longer is the lease?
The lease ends in February.
And so of the $300 something, who pays what? Do you pay that?
I pay everything. I pay the lights, I pay the water, I pay the rent. She just comes and goes as she pleases.
Okay, pardon?
I stay there. I live there. I buy household needs. I buy the soap, the laundry. I buy the needs for that.
Okay, I got you. But if you don't mind me asking, how old are you?
I'm 22.
All right. So
A single mom with my kid.
I got you. Who also resides there. So what's your position on this termination? You don't think you should have to move? Or what?
I mean, she's my mother. We never agreed on. It's just rent. She wants me to pay, and she wants me to get out. I don't understand why I need to get out. She's my mom. I mean, we've only had each other for all of our life. And when my dad kicked us out, it was her and I homeless, at a hotel and things and now she's trying to kick me out. I don't know why she needs to do that. If the lease is up in February and we both have to leave in February and right before the holidays and everything, I don't know. First she tried to take guardianship of my son, and then I'm not dead or running away. I'm not missing. I'm here taking care of my kid. So that's why my kid, and she got denied. And now she's trying to evict me because she didn't get lands. So it's just a whole situation, Your Honor.
Yeah. So here's the thing. You mentioned twice her being your mother.
I love her.
Pardon?
I love my mother, but I don't think the roles are, I don't know.
You don't think what?
I don't think she loves me the way I love her.
Okay. A lot of powers come with this robe. I can't make people love each other.
Right.
So, or how they do it. But why do you want to kick your daughter and your grandchild out?
I'm not trying to kick my grandchild out. It's my daughter that needs to go.
Cause I don't.
Okay, but whoa. But
I know technically it is.
that's a package deal.
I understand, but she.
So then my question is, why would you want to do that?
I honestly don't want to do that, but I need this because she's abusive towards me.
Marissa, you don't have a place to go with your child. Is that correct?
I mean, I really have to find a place, but I want to stay with my mom, and I'm not abusive towards her. She wakes up and she
took
said,
out my hand. You did
You
this
did
to me
that to
on
yourself.
No, you did it to me on Sunday,
I did
Larissa.
not do that to you.
All right. So if there's any type of violence or anything like that, then somebody needs to call the police, because that's not what I'm here to deal with. I'm here to deal with.
I understand, but she just thinks that I'm married to keep my mom close.
She just thinks what?
She blames me for everything, and she doesn't think she doesn't.
She doesn't. She says she doesn't do anything wrong.
She just needs to go.
Ma'am, and I don't mean this flippantly, but it's just true. A 22-year-old daughter telling you that she doesn't do anything wrong is absolutely normal, even if they're doing the wrong thing.
I understand. I was 22 once.
I know. And you know that you may just be doing the silliest thing in the world. The adults, the real adults, are all looking at you, but they will swear up and down that what they're doing is the right thing. That's just the nature of a 22-year-old. So let me ask you this. If I were to make a determination that it's a joint tenancy, which it is, and so that you can't evict her, what are you going to do?
I already told her that.
Well, ma'am, did I ask you? All right. So that was a 22-year-old thing that just happened there. Do not talk. What would you do? Pardon?
I don't know what I would do. I guess I'm stuck with.
Pardon?
I'm stuck with whatever your judgment is.
Yeah, you may be, but that's kind of what I'm getting at. What's your backup plan?
To find my own place and move out.
Okay, have you done that?
No, because
Because why?
the voucher's in my name. I'm stuck in this lease until the 18th. She has no way of paying it. She doesn't have a job.
Have you asked Section 8 about moving?
I had talked to them about it, but they said that I have to contact the landlord where we're living if they would let me out of the lease early. And no, I have not.
Did you talk to them?
No, I have not.
Why not?
Because I asked them to help me evict her and they wouldn't help me do that. So I don't know.
So what did you want to say? One?
I don't remember.
That was 22 also. All right.
She wanted to work on things with us. She wanted our relationship to get better. She wanted me to see her therapist, and I'm open to seeing her therapist, but I don't think he's like all there. But I'm like, whatever.
Well, okay.
We'll make it
Let me just tell you this, because here's what I'm going to do. I'm not going to give you guys my decision today because I don't think you guys are ready for the decision. You haven't explored all of your options and what they do. You haven't explored necessarily all of your options, but you are going to figure out a way to make do. Right? Now, I'm just going to tell you this, and maybe the two of you ought to think about some of these things I'm about to say. Marissa, you tell me you love your mother. Sometimes you have to meet them halfway. You have to have maybe a greater understanding of where they're coming from and whatever. Sometimes that can be, particularly for a young person, it can be grueling because you don't understand why they may be operating in the world that they're operating. But you just have to do it. And you have to go through time. And if you got to go talk to somebody to try to understand maybe what she's saying, that's what you got to do. Because guess what? In the end, you get one. That's all that you get. And young lady, while young people don't think that they think they got all the time in the world and can do all of those things, you get one, and if you blow it, there isn't another one to come along, right? And from your side, your son's name is Lance, he gets one. That's it. Now, for you, and I don't mean to say this, I probably you're going to get in some trouble, but daughters are challenging. I will just tell you that. I've got one of each. Daughters are challenging. The boy was a lot easier for me. My daughter's 26. I still don't understand. I listen. But she's going to operate in her way. And when I tell her, you've got to meet your mom halfway or try to understand, you know what? You just have to be quiet. That's part of your damn problem. Excuse my language, but it's true. You have to just shut up. Because I bet you, you've interrupted me twice, and I can bet you when your mom's trying to explain something, and it may not come out as articulate as she may want it, she may not even fully understand the emotion that she's trying to explain to you, you probably don't shut up and listen. You ought to try that. It can be cathartic. If you love her like you have proclaimed here, you would do it. And sometimes you just have to understand. That's a whole different generation than you probably grew up. Her whole thought process is just different. And you can see it just by what's happening in this courtroom. You have not once during this proceeding interrupted me at all in terms of what I'm saying. This one, it's been at least twice. You may not like it, but in some ways, that is what it is, at least at this point. You have to accept the fact that if you offer for ways for her to engage and she doesn't want to engage, while it hurts, you just have to let it go and you don't try to force it. Because if she doesn't understand that she doesn't get another mother, that's not your problem, that's hers. You got me? And it sometimes, and I see it all the time, it can be one of the most painful things in the world because that person in front of you is at least half you, and you can't believe they're acting the way that they're acting, and that hurts. So what I might suggest, if your mother is offering that you go to counseling, whatever you think of that person, whatever, maybe you show the gesture to your mom and go. So here's what I'm going to do, ladies. I don't think this is going to be sorted out in any given period in time, but I'm going to give you at least a week to try to figure it out, act like grown-ups, and maybe the two of you, and I'll say it this harshly, maybe the two of you should stop being so selfish and think about that little guy, Lance, and think about that he's got these two women there that he's got to figure out what they are, and neither one of you are acting in an appropriate fashion for him. So I'll see you guys in a week, oh joy, at 2:00. Start acting like adults, figure it out, come back and tell me something. Wait, what?
Lance has school, and I have to pick him up.
2:00, figure it out. Next Friday, 2:00, figure it out. Have a great weekend. Seriously, you're going to walk ahead of your mom? Thank you for opening that door. Because otherwise I was going to have somebody come out there and snatch you up. You just, no, quit talking to me. Jeez, Pete. If my daughter did, that would not be a civil case. I don't almost want to go down the hallway and just run up. No, okay. Really, I can make it right. I'll take my robe off. Okay. You don't let me have any fun. Okay. Sycamore Meadows versus Deja Thomas. You may be seated. Back on the record in case of People's State of Michigan versus James Whitley. Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett, appeared with now Mr. Whitley sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern.
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
Well, there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim. I said, why, we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Does that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it said?
because at the time I believed that it was grievable.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client or to do nothing if your client wishes that for you to do that as the defendant. This behavior, that behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
was trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss. And you.
I did not.
If you start this exam, she's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward to this. Right.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule.
I felt this case was different because this is not a situation where, this is a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who the her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Savage.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, Your Honor.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice. not just with me, but with your ticket to practice. Court's in recess.
All rise. A district court for county of Washington, state of Michigan is now back in session. The hour
May be seated. Back on the record in the case of the people, state of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
the defendant. So it's very brief, and I don't want to have to bring the lay person back.
Understand. Mr. Bennett.
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work for?
Yes. Thank you.
Oh, that's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as the prosecutor if you're going to self-report so that maybe others of us don't have to take any action.
Yes, Your Honor.
Preliminary examination in this matter is adjourned. July 1st, 2024, 10 a.m. before me. Thank you.